Thank you very much for the kind introduction and for having me here. I also have a presentation which I would like to open. In fact, the Indian case had to be left out for the presentation because it just simply would be taking too long. I will start with a poem. All good people agree and all good people say, all nice people like us are we and everyone else is they. The us and they, them is very much part of this presentation as well, as it was also yesterday partially. I will start with Rwanda and the religious elements of the genocide there. In the Rwandan, sorry for the terminology, now I caught myself saying it as well, the Rwandan genocide. Narelle, thank you for pointing that out. The religion is not usually foregrounded, but there are several religious elements. And let me take you a bit back in time. The explorer, Count von Götzen, a German explorer, upon his arrival in Rwanda in 1894, was surprised to find very sophisticated social political structures in the Tutsi monarchy. And in the spirit of his time, which was very much framed by racialist science, he considered all things of value to have originated in Europe. And this was seen as the birth of the Hamitic myth, whereby the Tutsis were seen as originating from the Horn of Africa and as a subgroup of the Caucasian race. And you see it here in a map, an ethnographic map portraying the Hamites as a subdivision of the Caucasian race. And that makes them also in the same group in blue, as you see, the Aryan. Hamites and Semites are all in the same group of people, which are considered at the top of the racial hierarchy. The Hamitic myth is a religious, has a religious element because it is based on a biblical story. 130 years later, it was misused, amongst others, by Leon Mugesera. And Narelle, I read a very fascinating paper by you, which analyzed the case of the Mugesera speech. Leon Mugesera, he was a senior politician in the extremist Hutu movement, and in his speech, he said, "I am telling you, the Tutsi, that your home is in Ethiopia, that we will send you by the Nyagaboro so that you can get there quickly. And the Nyagaboro is a river that leads back from or through Rwanda into Ethiopia." This meant the Tutsis were presented as foreigners in their country, and it had a direct consequence that they were being killed and thrown into the river in order to be sent back home, here from a memorial ceremony. Mugesera was convicted in 2016 of incitement to genocide and sentenced to life in prison in Rwanda, following a very complicated case in Canada. The religious element is also present in the 10 Commandments that the Hutu extremist movement wrote, and that presented some kind of ways of living that were present for all the Hutus in Rwanda. The identification of the victims became very easy because of the ID cards that were introduced by the Belgian colonialists. So to the legal framework. We have seen it in previous presentations. It is the intent to destroy 4 exclusive groups. And this protection of 4 exclusive groups is considered one of the largest shortcomings of the law of genocide. And by interpreting the law, of course, the courts determine the contours of these 4 groups. And that's why their interpretation is crucial in order to establish whether a victim was a member of a protected group, and therefore the perpetrator can be prosecuted. It is notably the group as a whole that is protected from a genocidal attack, and not the individual that is just part of this larger construction. And the individual is chosen for membership in one of these groups, not for individual qualities, but as a member of the group. So how did the courts define the religious group? In effect, there are very few efforts of defining the religious group. It started, as we've seen yesterday briefly, with the Akayesu case, as one whose members share the same religion, denomination, or mode of worship. The problem of such an objective approach is that it, for example, does not address issues of agnostics, atheists, sects, cults. How are they packed in? Of course, you could maybe subsume them under the mode of worship, but then again, that often implies some higher deity that one prays to or worships. The Kayishema case, 1 year later, slightly modified this definition to denomination or mode of worship, or a group sharing common beliefs. So that opens up a bit more and could also implement other or integrate other groups rather than the strict world religions. In the recent case before the ICC pre-trial chamber on the Rohingya case, it was noted as one whose members share the same religion, denomination, and mode of worship, and thereby returning to the Akayesu definition. So the bridge that I hope to be able to construct here, illustrated by one very famous bridge at the Norwegian west coast, is that genocide is an intergroup conflict. So the group element is very, very central. And intergroup conflicts, they originate in an understanding of competing group identities. So it's not only the group, but it's two distinct group identities. Group identities are considered fluid, while the law seemingly protects only for exhaustive and probably fixed group categories. How can we get this apparent, now I'm completely lost for words. I will just move on and suggest that we can bridge it by means of social identity theory, which is them versus us. A quick introduction into this very influential theory. The personal identity of an individual is defined through the belonging to a group. And different characteristics are assigned to different parts of the group. First of ourselves as member of our group, but also as the others, which creates a comparison and creates also two opposing groups. And indeed, research has shown that the mere perception, even if you don't physically actually belong to a group, but the mere perception of belonging to distinct groups is sufficient to trigger intergroup discrimination and the favoring of one's in-group. Simplified, we define who we are by who we are not. The next step is an identity competition. It is very essential for the inception and the escalation of intergroup conflicts, and not only genocides, but any type of intergroup conflict. The identification of the outgroup, of the others, involves negative values and prejudice. So you assign to them some kind of negative characteristic, which makes it even easier to target them at a later stage, to discriminate them, to stigmatize against them. And due to their perceived inferior characteristics, the outgroup is considered of a lesser value. And talking about dehumanization, this is also included in this package, of course, because they're of a lesser value. They're not seen as human as us, and therefore more easily targeted, and also much more perceptible to any type of discrimination and attacks. We've heard that groups have several layers of fluid identities. However, prior to and during a genocide, the multiplicity and the fluidity of these identity markers usually vanishes. It is because the perpetrator singles out one, it can be imagined or real characteristic of the victim group that is augmented and then presented as a threat to one's own group. So the threat element is an important feature in all genocides, and it justifies the attack in order to secure the survival of our own group, the in-group. Recent case law avoids defining the protected groups. For example, in the Mladic trial judgment of 2017, the tribunal defined protected groups as national, ethnic, and/or religious groups. So it just packed them all together. And yes, the Bosnian Muslim and Bosnian Croats have elements of all three. They're national, ethnic, and religious. So legally speaking, it is not incorrect. Similarly, in the judgment by the ECCC on Cambodia, the chamber finds that the Communist Party, in the effort to establish an atheistic and homogeneous society without class and division, targeted the Cham as an ethnic and religious distinct group. So both elements are present. This, while legally correct, does not correspond to the pre-genocidal dynamics of othering, and is somewhat problematic with the view of the principle of legality and legal specificity. So you just say they're in one of these categories, but we do not want to really define them. Also in the pre-trial chamber, or in the Rohingya case, and this notably was with regards to the crime of persecution, the Rohingya were seen as being targeted on basis of ethnics and/or religion. But rightfully, the chamber did see that this is an issue of group identity, which is, in my view, very important development in the case law. As said, the legal characterization can stand in contrast to the social dynamics of a genocide. So what then is the role of religion in genocides? Religious attentiveness is rarely actually the motivation for undertaking genocide, and often plays an important role in the creation of the others. So religion is not the core driver, but it is an important element that plays into the creation of the others. Religious worldviews and rhetorics are used regularly in the planning and execution of a genocide, as we've seen in the Hamitic myth or the rhetoric by Leon Mugesera. Religious identity fault lines are often used by means of rhetorics based on a myth of common origins. And that we have also seen, for example, in the case of Serbian nationalist propaganda, that was based on a myth that identified the Muslims as traitors in the Battle of Kosovo as far back as 1389. But it's this myth of the creation of two opposing groups that finds its origin, amongst others, in a myth of common origin based also on different religious identity fault lines. And the leaders of the groups use or misuse this idea of a homogeneous group in order to intensify the conflicts amongst the groups. Another picture from the west coast of Norway. The bridge that I suggest should be constructed is genocide against a religious group is an intergroup competition gone wrong, where one group intends to destroy another group for its ostensive, imagined, perceived religious features. And therefore, religion has to be understood from the perspective of the perpetrator, who tries to defend his group against the threat, the perceived threat of the outgroup, and the polluting religious identity. And in doing so, if one sees it as an intergroup competition, social identity theory can assist in the legal interpretation of the victim groups of genocide. Thank you very much.